All right, good afternoon or good morning to everyone wherever you are in this country. Thank you for joining us for our webinar today. We're very excited to have Laura Russell, one of CSAJ's expert advisors, come and talk to us about credit reporting and repair for survivors. The webinar goes from now until 2:30 p.m. Eastern Time. We're very excited to have you and to have Laura with us. Just a few technical things before we begin. I'm Sarah, your host. You should see me on your right-hand toolbar. And if you have any questions or technical difficulties, please contact me. We are recording this webinar, and the recording and materials will be available on our website shortly after this live event today. You are also on a super special listserv and will get a direct link via email within a couple of days after this webinar once we get everything all up. A few other technical details just to orient you to this platform. You should be seeing the PowerPoint slides in your left-hand side. And on the right-hand side, that's where all the magic happens. You can click on the word bubble in the bottom right to start chatting with us. You can send Q&A to me, the host, or any of our presenters today. If you have a question, please select the little hand to raise your hand, and I'll check in with you and make sure you're doing all right. And we really hope that you use this. We have a lot of opportunities for discussion via the chat, and hopefully we can even unmute some of you who have called in later today to talk with us live towards the end of our call today. And just to make sure everyone has a chance to kind of play around and practice, click on that little word bubble in the right toolbar at the very bottom right and tell us who you are. What's your name? Who are you coming to us from? What organization do you work with? What's your role? Let us know a little bit about you. All right, well, we'll let you keep doing that. Hopefully you start getting familiar with some of the tools here, and we will be in touch throughout this webinar. So now what I want to do is introduce CSAJ's Executive Director, Erica Sissman, who's going to walk us through a few other announcements today and introduce our faculty for this webinar. Erica, are you with us?
I am. Thanks so much, Sarah. So I'm going to try to see if I can move this along. Okay, great. So thanks everybody for joining us today. We are thrilled to have you participating, and as Sarah had mentioned, hope that you will be active participants in today's webinar because we know that we have an unbelievably knowledgeable and diverse group of advocates on this call, and so we want to make sure that we all are able to benefit not only from our faculty's knowledge, but also from all of yours. So we look forward to having some interchange with you throughout the call today. So this first slide, I just want to mention that today's webinar is one of a two-part series that CSAJ is hosting related to credit and issues facing survivors of domestic violence. So today's webinar is part one of the series, and it focuses on credit reporting and repair for survivors and is featuring Laura Russell, CSAJ's expert advisor, as faculty. And then the second part of our series is taking place on Thursday, October 8th, from 1:30 to 3 p.m. Eastern Time. And it's going to be focusing more specifically on credit checks and the barriers that survivors face in terms of employment. So there are all sorts of policy issues that are pretty center stage right now across the country around this issue of credit checks for employment, and so the conversation really does promise to be a very rich one. So we hope you'll join us for that webinar as well. I want to talk a little bit about some of today's webinar objectives, which are listed right here. So we hope that after this webinar today, you'll be better able to recognize credit-related economic abuse. You'll be able to understand credit reports, credit scores, and their purpose. You will have knowledge around how to protect survivors' future credit and identity. Learn more about how to dispute and rebuild survivors' credit. Understand more about credit reporting laws, rights, and some new developments in the credit reporting and credit law front. And also learn how to craft strategies that are addressing credit-related challenges specifically faced by survivors of domestic violence. So those are what we are hoping folks will get out of today's webinar. I want to, before I hand over the program to our faculty, who I will just introduce in just a moment, I just want to speak quite broadly about the Center for Survivor Agency and Justice. Of course, that is the organization that I direct and that Sarah is also project manager for. And just generally speaking, for those of you who are new to us, and I'm thrilled to have you with us today. CSAJ has a vision and mission in terms of the scope of our work. Our vision is one that is focused on equal access to safety, economic security, and human dignity more generally. And the mission of CSAJ is to promote advocacy approaches that remove systemic barriers, enhance organizational responses, and improve professional practices to meet the self-defined needs of domestic violence and sexual violence survivors. So today's programming is comes out of our project that is the Consumer Rights for Domestic Violence Survivors Initiative, and you can learn a lot more about that project on our website, as well as gain all sorts of resources related to this initiative. So we hope that you'll check that out afterwards, and feel free to reach out to us if you're interested. So today's faculty joining us today is Laura Russell, and Laura has worked with the Center for Survivor Agency and Justice for many years at this point. She's one of our expert advisors, and her expertise and wisdom has been really integral to CSAJ's work. She's the supervising attorney of the Family Law Unit of both the Bronx Neighborhood Office and the Harlem Community Law Office of the Legal Aid Society in New York. She's also the co-supervising attorney of the Domestic Violence Unit and formerly supervised the Foreclosure Defense Project of the Bronx office. So clearly, Laura holds very unique expertise, and we are really privileged to have her with us today. Without further ado, I'd like to hand the program over to you, Laura.
Thank you, Erica, and welcome, everyone. So the objectives for today and what we're going to cover, we're going to talk about credit reports and why your clients should be checking them, specific concerns related to domestic violence survivors around their safety, what is a credit report, who creates these reports, how to get them, how to read them, dispute them, and then we're going to talk a little bit about rebuilding your credit and about debts, specifically about the difference between debts when parties are married and when they're not married. During any of this, we're monitoring the chat and the Q&A, so if anyone has questions, feel free to type them in. Everyone is muted at this point except for myself, so please use the chat and the Q&A for questions and comments. Okay. So we're going to start with a poll. how familiar are you with credit reports? So one of the things that I always tell advocates is that if they don't have if they for some reason have not been able to access their own credit reports, then it's difficult to talk about accessing it with their clients and getting their clients comfortable. A lot of people don't want to look at their credit reports. They're afraid of what's on them, but it's always better to know. So how familiar are you with your credit reports, with credit reports? Do you know, A, my web browser opens to annualcreditreport.com. B, I pull my clients' credit reports on intake. C, sometimes. D, I occasionally review them. And E, what's that? So, and if E is your answer, that's good because that's why you're here today. So,
and just to let you all know, the poll should be open in your right-hand toolbar, so you should be able to answer. And there you go. Now I see more folks going in. Thanks. Okay, I'm going to close it. And you should be able to see some of those results.
Yes.
So it looks like the majority of people occasionally review their own credit report, which is good. And there are some people who are familiar with it, with credit reports, and pull them for their clients. So I will say in my area, when I usually wait, not on intake, because it is traumatic sometimes for clients who have never seen their credit report to suddenly see it, but I do when I'm working with them, usually by the third or fourth meeting, ask them specifically, can we pull your credit report, can we look at it, and just take a look at it so we have an idea of what's on it. And then it takes a couple more meetings before clients get familiar with the concept of what's on it and what they could owe before I sit down and really talk to them and explain it to them. Some clients, of course, want to know very early on in their cases. Some want to wait till the end, but I do try to pull it after the client's been a little comfortable with what's going on so that we have an idea of what's on it, because it is a starting point for helping with a lot of issues that the client has. So now we're going to talk about recognizing credit-related economic abuse. So credit-related abuse or economic abuse, some of the things to look for are, are all the debts in the survivor's names. So, for example, are all the parties have been together for 5 years, yet, person number one has all the debts in their name, and the other person has no debts whatsoever. And so, or one of the partners has all the assets in their names, and yet all the debts are in the other name. You want to look for things that are signs of coerced debt. So, was there fraud? Was there manipulation? Did the client not realize, and this is when pulling the credit report is important, did the client not realize that there was a debt in her name or his name? Did they realize did they think the debt was only for a couple $100 and it was being paid off and it wasn't? Are there accounts on there that they've never even heard of or used? Do they have any access to enough money to pay their bills? So many times they'll be given a certain amount of money for food or clothes, and they won't have access to any additional monies, and they won't be able to pay any of their consumer debts with these monies, so their credit score will drop because their debts will go into collections. And it'll be done this way on purpose so that with the low credit score, as you all will learn or know, it's very difficult to leave your abuser. Does anyone have any other common experiences that survivors have faced related to credit or debt when they're either trying to leave or at any point during the relationships?
So we're going to ask for folks to type those in the right-hand side, where in the chat box.
Yes, there's a chat box and a Q&A box, so you can type it in either one.
Yeah.
While people are doing that, we did ask a lot of you during registration to give some of your insights and the experiences you're seeing survivors face in your work. And we got a lot of interesting responses back on some of these different tactics that Laura was just mentioning, everything from coerced debt, racking up credit card debt, abusing titles and loans and bills, not paying for things, controlling finances, and then a lot also on a lot of the further implications of credit, such as restricting housing and employment options, utility services, and other things like that. And I'm seeing a couple of things pop in now. Laura, I don't know if...
Yeah, some of them are related to the types of behaviors that lead to credit problems, and some of them, some folks are just underscoring the barriers that are created. So barriers in terms of housing and access to the rental market, as well as subsidized housing programs. And some folks are talking more about the impact of being intertwined with somebody by virtue of being married to them, and how that impacts one's credit score and all of the barriers that arise from that.
Yes, and I'm seeing some more good examples of coerced debt, such as forcing them to provide verbal verification on the phone regarding accounts. Of course, taking their names off deeds so they have no right to the property, even though they could still be on the mortgage. So they're still liable for the mortgage, opening credit accounts in their names, using payday loans. We're lucky in New York that we don't have payday loans. They were outlawed by our legislature, but unfortunately, many states still have payday loans. And of course, there's a lot of clients don't know what debts they're liable for and not liable for, especially when they're married. They have no idea that they may or may not be liable for. And even when they're not married, collection companies will lie when they call people to try to get money from them and claim they're liable for a debt when they may not be. So there's a lot of misinformation that's floating around, unfortunately, and our clients come in asking about those. Okay, so why should one check your credit report? Both for financial responsibility and safety reasons. Your credit report is a valuable tool to discover who knows or is learning about you. And financial reasons, of course, would be the biggest one. You know, a credit report is accessed or pulled, we call it pulled, for anything you could think of that might have to do with paying a bill on a regular basis. So not only credit cards, cell phone contracts, leases, mortgages, but also for utilities, for car insurance, for private health insurance, for employment applications, even though that is not permissible in certain jurisdictions. They will still pull employment applications. So your credit report is very vital to trying to leave us in an abusive relationship, to try to get a new cell phone, get an apartment, get utilities, as well as get some credit so that you can have just a cushion just in case you need it. And it's a very complex document. So safety reasons, of course. Credit reports show a lot of things. They show identity theft, so they might show some credit pulls that are not yours. They might show some credit cards that are not yours. They might show the wrong address, which means that bills are being diverted to another address. They might show what's called impermissible pulls. So I cannot just go online and pretend to be someone else and get their credit report. That is illegal or impermissible. I must have a valid legal reason for getting a credit report, or I must have consent of the party getting it. So you can see if there have been impermissible pulls. So for example, you can see if the Discover card pulled your credit and you've never received a Discover card or asked for a Discover card, it's possible that there might be some identity theft going on. You also want to check for the current identity. If you're do a name change or even do a Social Security number change, there are the credit reports can be merged between the old and the new name. And so in essence, making the fact that you've changed your name completely useless to the creditors and anyone who has access to your credit report. So you definitely, people want to be checking their credit report pretty much as soon as they can once they leave, because they'll see who's accessing it and why. So some more credit abuse tactics, some of which we talked about. Abusers usually keep assets in their name and debts in the survivor's name. This is a common thing. We saw this a lot even with mortgages. Before the mortgage crisis hit, there were a lot of deeds that were only in the husband's name and mortgages that were in the wife's name, which is impermissible, illegal, fraudulent, pick a word. But nonetheless, it was happening a lot. Abusers also can track whereabouts. They look at ATM usage. They can look at credit card usage. They can look at banking habits. So if you have a client who's fled to a different county and has a debit card or a credit card and the abuser has access to that or has passwords, they can go online, they can see where the ATM or the credit card was used, and they can track the person down to at least the general vicinity of where they might be. There are plenty of keystroke software out there that allow people to improperly or illegally obtain passwords. So the first thing I always tell my clients is they want to go to a secure computer, not one in their home, and change all their passwords. It is very easy to obtain credit cards, especially with the internet, in someone else's name, especially if you have their information like you would of someone who you've been in a relationship with. They can pretend to be anyone on the internet. There's no verbal notification now. Everything is done electronically. And one of the biggest things that I see, especially in where I practice, is that the abuser keeps all the assets in the family members' names. So the house they live in is in the mother's name or the mother-in-law's name. The car is in the brother's name. And so what you have to do is dig through lots of different financial records to see who actually paid for and is paying for those items. But we see that a lot where the client will come to us and says, well, I don't have access for, I don't really own the house because the house is in our father-in-law's name, even though I pay the mortgage and we've been living there and we put the down payment. And they'll always have some excuse, my credit was bad or the bank wouldn't give me a loan. And sometimes it may not be an excuse, but the bottom line is the abuser wanted it that way. They wanted to make sure that they could never access the assets if there was a divorce. You also want to talk to the client about filing income taxes. I do have a lot of clients whose, especially if they're married, whose partners have filed fraudulent income taxes or filed income taxes to get a refund and they haven't even known about it. So that's something you want to talk to them about. The one that I absolutely hate, I have a personal pet peeve, is when clients talk about how they got an allowance. Allowance, it's demeaning and degrading. First of all, just the term, because it's not meant for an adult. It's usually reserved for a child who doesn't know, or you need to understand the concept of money. But then they get an allowance for, you know, $20 a week, and they're required to buy food and then show all their receipts and then give them back all the change. So it's a common problem that our clients aren't able to save any money or have anything else left over for themselves. And of course, what we did talk about, which is coerced debts, which are debts that are forced upon the survivor by the abusers, either by fraud or duress or acquiescence. So the debt was illegal to begin with, meaning that the survivor had no knowledge of it, but when they found out, they accepted it and continued to use it, and so it became a credit card or a debt that the parties used together. And that's and coerced debts are some of the hardest debts to deal with in consumer law, because the survivor has given up a lot of her remedies by being the one who opened the credit card or accepted the credit card. So, okay, so now we're going to move on to talking a little bit about credit reports and understanding what they are. When you look at them at first, they can be very daunting, but they're somewhat easy to take apart, because every trade line, which is every different account, is the information is the same in every place. So they're going to, the information, once you know how to read one trade line, you know how to read them all. And the other thing with a credit report is it's somewhat like putting a puzzle together. So you have to see when accounts were bought and sold, because you'll have 3 of the same account on a credit report, but you won't know it's the same account until you look and see that one was closed or reopened or sold, or the amount of the debt is the same. So, and of course, credit reports are notoriously inaccurate, and we're going to be talking a little bit about how inaccurate they are and how we got a settlement. The New York Attorney General's office got a settlement to try and fix some of the inaccuracies, but they are notoriously inaccurate. So what is a credit report? Well, it's technically called a consumer report, and it's really a document that looks at a consumer's credit worthiness, credit standing, and credit capacity. Now, if you read this, you see it also looks at character, general reputation, personal characteristics, and mode of living. So basically what we're talking about is a document that you can put almost anything in there and claim it has to do with someone's character or general reputation or personal characteristics. So they're going to include pretty much every financial event that is in someone's life is going to wind up on a credit report. It can only be used for credit or insurance purposes, employment purposes, at some points during employment, and any other or authorized use under 168(1)(b). So the thing to recognize about a credit report is you can't pull, you know, if I'm representing the wife in a divorce, I can't pull the husband's credit report without his authorization, because that's impermissible. If Capital One is suing my client, they're not allowed to pull her credit report until they get a judgment. Then they can pull it to try to find information out. So you can't just go around pulling someone's credit report. You have to have their permission. So credit reports there are 3 big agencies that handle credit reports. And unfortunately, if you pull one, it doesn't mean that the same information is going to be on all 3. As a matter of fact, usually the information varies from one to the other. Some of the information is the same, some of it is different. Some of it is missing on one, some of it is just completely different numbers on the other. And what you also see with that is the credit reports, the credit score. And sometimes people will say my average credit score. They'll say, you know, average credit score. A credit score, because the information is different, you're going to have 3 companies that give 3 different credit scores. And so some, for a mortgage or for a credit card, sometimes they'll look at the average of all 3, and sometimes they'll look at the middle one, and sometimes they'll look at the lowest. So you may have a client who says, well, Experian says I have an 800 credit, but Equifax says I have a, 710 credit. And the reason for that is because something on Equifax is not on Experian. And I have seen credit scores vary in the almost 100 points because something was missing or something wasn't missing. Also, the big three look at different trade lines in different ways for credit scores. So they don't always use the same formula, which we'll talk about in a second. So the big three consumer reporting agencies are Experian, TransUnion, and Equifax, and those are their websites if you ever needed to get onto one of them. For a mortgage, many times they'll use something called a Novus, which is more complicated to get, and unless you've been denied, near impossible. Employment, they use LexisNexis and HireRight. There are other agencies. For all of these, there are other agencies, but I'm giving you the ones that are most likely used by companies. But there are small little consumer reporting agencies or CRAs popping up on a regular basis. For tenant screening, they do use a different reporting agency. It's called AmRent or RealPages. Tenant screening will also include times that your landlord has taken the client to housing court or any time the client has been in housing court. So what we see in New York City is in housing court there is an action to get the landlord to do the repairs they required. And if they bring that action, it shows up on their tenant screening. And because it shows up as a time in housing court, it's a negative factor. So even when our clients are trying to get services, it can show up on a tenant screening as a negative factor. So these are things that you need to be aware of and talk to your client about, especially if they're looking for housing. So talk a little bit about the score that I mentioned. FICO, which is Fair Isaacs, and I don't know why it went from Fair Isaacs to turn into a credit score, but Fair Isaacs created this scoring formula that it uses to generate a score. That score varies. Even though they all start with the Fair Isaacs formula and they all look at the 3 credit reports and what they come up with as a FICO score, there are some companies like a bank, for example, or when you're getting a mortgage or even getting a bank account, that will look at other factors and put other things into consideration. So, for example, Chase Bank. I had a client, she defaulted on a Chase Bank credit card and they sued her and it was paid off 11 years ago. It's not on her credit report. It's not on her credit score. Her credit score is quite good. She applied to Chase Bank for a credit card and was denied because of this past debt that at this point is 11 years old. Yet, she applied for Chase Bank for a car loan and she received a car loan far more in excess than she would have gotten in a credit score. So the formulas that they are using for the different products vary, and clients you should realize and recognize that unfortunately, as much as there is a mathematical formula and there's websites out there that help people figure out sort of what their score is and what the report says, that the entity that you're applying, that the client is applying for credit, will look at other things, and different things will factor in based on what type of product they're looking for. So, and I will tell you right now, I've done this for a long time. I find no rhyme or reason in any of it. I have clients who get denied credit cards but get mortgages, which really is a lot larger of a debt than a credit card. So I don't think there's the rhyme or reason is nothing that I think we'll ever be able to figure out. So what I talked about before, some impermissible uses. So you can't pull a credit card or use a credit card for litigation. You can't use it to try to determine if someone isn't living in their residence and they're required to use it as a primary resident in a housing court case. You can't just go and get a credit report on your spouse, your relatives, or anyone. There must be a permissible use. If you have somebody has a judgment, then they can permissibly pull the credit report if they have a judgment, and they can put that judgment on the credit report. But they can't do it just when they start the litigation to see what's out there. So when I talk about pulling your client's credit report, what I do is I sit at my computer with my client and we pull it together. So I don't say to my client, I'm going to go pull your credit report, come back in an hour, for two reasons. One, I want to be able to pull it at my computer for them with them watching it. And two, the credit reporting agency, to get the report, is going to ask me very specific questions that I may not know the answer to, with the goal being that it is my client seeking the report and they will know the answer. So this is more of the U.S. code that talks about the consumer's credit report. And everyone is entitled to at least one free copy of their file per year from all three of the nationwide CRAs. That's the big three that we talked about. The file is slightly different than the report. The file does not come with a FICO score, and the file is more raw data than the actual report itself. The report is a little bit more cleaned up. They are entitled to see it if they believe they're a victim of identity theft. They can get a free file if there was an adverse action, and what that means is if they were denied credit in any way. If they're unemployed or on public benefits, they're also entitled to a free file. So there are multiple points in what's going on in a client's life that they may be able to get more than one free file per year. So let's talk about protecting survivors' credit and identity. So the first thing you do, if possible, is to get the credit report and to try to get it safely. So what I like to do with my clients is we sit at my desk in my office and I pull it through the internet and it downloads you open it right onto your computer and it downloads. You can download it without giving any additional information such as an email address or a phone number. And you're going to be able to do that if your client believes or if the credit report hasn't been compromised. So if the credit report has been compromised, meaning that if she has debts that she can't recognize or addresses on there that she can't recognize, it is possible that she's not going to be able to access the credit report online because he is not going to be able to answer the questions that are required to get the credit report, such as, they're going to list 3 addresses and they're going to say, please select the address that you lived at 5 years ago, and you're going to have to know that. And so if their address has been compromised, they might not know that, and therefore they won't be able to get it online, in which case they can mail in the form or they can have them call. I always tell clients that any address you give a credit reporting agency will appear on their report. So if you believe that someone has been accessing your report, you need to give an address that either that the party has been accessing it knows. So if it's a domestic violence situation and the survivor gives their sister's address because the abuser knows their sister's address, that's fine. I do offer my clients the ability to give our address, but I work for the Legal Aid Society, so my address is a law firm. So the victim or survivor has to know that a law firm is going to appear, which won't affect their credit, but it will alert who's ever looking at their credit report that they're talking to a lawyer. So if they're in the middle of litigation, this is not a problem. If they haven't started litigation, you need to think about that. So you can do it by phone, but many times if there's been a compromise, you have to do it by a mail-in form. And it does take a while if the information has been compromised on the credit report, unfortunately. So So this is what I just said. Whatever address you provide will end up on the credit report. So let's talk about what other creative strategies you may have used to address this issue. So where do you think you might be able to send the credit report, or and where have you sent credit reports because the client's address is confidential? And we can put this in either the chat or the Q&A. So in the meantime,
I know that there are several kind of innovative strategies that folks have talked about. Some of you actually I know are on this call. So I'd love it if people would be willing to share some strategies that may fit certain people's circumstances and not others, but just so that we have kind of a toolbox of ideas as we do this work. And I see a whole bunch of stuff popping up.
Yes. So we have the P.O. box. So our agency opened up a P.O. box for clients. That's very good. You can use P.O. boxes to get these credit reports. So, and just to go back, the FICO score and the credit score are the same thing. Credit score is the slang term for the technical term of FICO score. So, and I do see there's a question regarding someone taking out credit cards in their minor daughter's name. So the first question is how old is the child? Are we talking about a teenager? If they can't answer the questions, they have to do it by mail. And if they're old enough, if the minor daughter or whomever is under 18 is old enough, they should write the letter themselves. Otherwise, they can write the letter on their behalf if they're too young, and if they have a custody order, if they have some other document that shows that they have custody of the child, they should include that. It will, again, it does take some time, but as long as you can prove that you have, that child is yours, they will be able to release the credit report to you.
Somebody said that they encountered some trouble using a P.O. box online.
You can't use a P.O. box online, but you can use a P.O. box for when you're mailing it. And they will try to verify that the P.O. box actually exists. So. Some CRAs will want to verify the address based on another credit card. So if the client is using the P.O. box for all their credit cards, the credit reporting agency isn't going to care. If the client says, you know, her address on all her credit cards is one address and then the P.O. box is different, they may want additional or further proof. The problem is that they can't just, they're not supposed to just refuse. They need to say, we need this additional information or we need this additional information. And there was a question about verifying the address. The only thing they mean by verifying the address is seeing if there's any other bills being sent to that address. So you can talk to your client about that. You know, can they send a credit card bill to that address? And then once they do that, then the CRA will release the information. They can also send domestic incident reports or police reports if they want to show that this is why they're using this address, or orders of protection just to get the report. I know it's a lot of information to give an agency for just trying to get an access to your file, but unfortunately sometimes they're going to require additional information.
Okay, so maybe we should share some of the other strategies that may not be popping up here, but I think we have on the next slide.
Yes. Okay. So some strategies, some of which we talked about already. Use the domestic violence organization that you're working with address. or public agency, family or friends. I find that works the best because a lot of times the abuser will know the sister's address, and the sister doesn't mind getting it because it's 1 or 2 pieces of mail. You can also get a second phone if you're, and I learned this from a security expert. So apparently Boost Mobile, just in case you're curious, is the closest thing you can legally get to what's called a burner phone. So Boost Mobile phones, and he claimed that they were created specifically for criminal activity. I'm not going to say that, but I will say that Boost Mobile phones are very, very, very difficult to trace. They don't keep the records that Verizon keeps. They don't keep identity information. So if you need to give a CRA a phone number, if you're doing this by phone and you want to give them a phone number, and your client has some, obviously these are not free, your client has some money, then a Boost Mobile phone might not be such a bad idea because it is very, very difficult to trace. And a lot of people apparently do use them as what is called burner phones. So that's my lesson in how to be a better criminal, and we can move on. So you can create a new email address. Some people just have an email address just for certain things. I know a lot of my clients create one just for emailing their former partner regarding visitation or custody. You can also partner with a financial institution to do what's called a soft pull. So a soft pull is when someone accesses your credit report, that is not you, but it doesn't affect your credit score. So when you get solicitations in the mail for credit cards, they've done what's called a soft pull, which means they've, in the desire to give you credit, they have looked at your credit report without affecting the credit score at all. So which means that there's a belief that you're not going to be getting any credit from this pull, but they just want to see what's on it. So there are financial institutions that will partner with domestic violence agencies to do these soft pulls for their clients. And of course, when you're a financial institution, you have a very easy access to the CRAs. I would recommend, if you're doing this, to look for partnering, to look for financial institutions that are local or that are smaller. Some of the big agencies did it in the past, partially because they were ordered to by the Department of Justice to make amends for some event. And a lot of them are not doing it anymore. So you may, but you may find that your local bank or a credit union will be more amenable to doing this than a larger institution. So.
And we have some partners who, one of our expert advisors, Katie Von der Linde, when she was working with an organization out in St. Louis, I know that they had sort of a formal partnership program that was for the purpose that you just described, Laura. So if folks are interested in learning more about that, we can certainly connect you with more information.
Okay. So I find this slide the most amusing. In theory, CRAs are supposed to follow reasonable procedures to assure accuracy. It's not strict liability, it's a balancing test, and they're permitted to presume reliability from any source, which means if Macy's sends them a trade line, they can just assume it's valid. They don't have to check it at all. They don't have to double check. They don't have to confirm with Macy's that they translated it properly, because it's all sent in binary code, actually. So what this basically means is that the credit reports are not very accurate. Even people who have excellent credit, there will be plenty of mistakes on the credit report, especially if you've been intertwined with another individual. So if you are married to someone, your exes, or if you are married or were married, all their information will magically somehow wind its way onto your credit report. So you'll have addresses that weren't yours. You might have credit cards that aren't yours. So you really have to look through these with a fine-tooth comb. So, okay, we're going to talk a little bit about identity theft. So, identity theft usually is when the person who commits the identity theft is usually known to the survivor. And it's when the abuser or someone else uses personal identification information to either take out credit, take out mortgages. I've seen everything: credit, mortgages, cars, you name it. I've seen identity theft where they've gotten a whole new driver's license and they've gotten tickets. And so you can see it in all aspects of someone's life. They can also use discarded mail or credit card receipts, security breaches, so somebody loses their ATM or somebody uses an ATM that has illegal software in it, and you'll see, and it could be identity theft. So I had a situation where I used this one gas station when I would go up to Albany, and every time I come back from Albany, my credit card would be compromised, and I couldn't figure it out until the last time I went up to Albany, and I used that same gas station, and then, a week later there was an extra $5,000 worth of charges on my card, and then it dawned on me that gas station, because that was the only thing I used my credit card for in Albany, that gas station must have had fraudulent software in its credit scanning system. And so, but it took me a few drives to Albany before I realized where they were stealing my credit information from. So if someone is a victim of identity theft, the best thing they can do is file an identity theft report with the FTC or the police or the post office. I recommend the police. I will warn you, the police departments are not very good where I am, which is New York City, in taking ID theft reports. Sometimes you can force the issue. Sometimes they will allow you to take a report that's mailed into our capital but is not considered a police report that they're going to investigate. You can also dispute the charges with the creditor directly, and that's something you should do both. You should, if you're going to, you should definitely encourage people, if they are a victim of identity theft, to file a police report and dispute the charges immediately. The longer that the charges stay there, the harder it is to dispute them. You can also put a fraud alert or a security freeze on not only your accounts but on the credit reports. So what these are ways where the credit report cannot be accessed by anyone without approval from the victim of identity theft. You also might see identity theft in merged accounts. So there may be some accounts that were combined or merged where maybe your client did have a piece of the account but not what's on there anymore. So these are things to look for when you're looking at a credit report. So the way to block an identity theft debt is basically you have to file a police report. That is one of the key elements here, is that you have to file the police report, and then they have to give a statement as to how this is not their debt. Sometimes that statement can be very easy. So, for example, when I had these fraudulent charges in Albany, I basically sent a statement that says, I don't live in Albany. I live, 2 hours away, and on these days when this occurred, I wasn't in Albany, and so that was accepted. I did not have to file an identity theft report. because it was one credit card. It wasn't a full stealing of my identity. But if someone has their identity stolen, they do have to file an identity theft report, which is, again, a police report, or they can file with the FTC. And the credit reporting agency has the ability to look at all this and determine whether they feel that the survivor or whomever is filing the report is accurately filing the report. So if they feel that the report is inaccurate, they have the right to say that we're going to keep these on the credit report and that you are not a victim of identity theft. So those are things to be forewarned about. So common errors and problems. These are common errors and problems on your credit report. So resold debts, changes in servicers. So when I was speaking of looking at a credit report and you see the same debt 3 different times, that's normally because the debt was resold. So the debt was originally with Capital One, and then Capital One sold it to Midland Funding. So it didn't come off your credit report from Capital One. It just went, they just added a trade line for Midland Funding. So it looks like you have 2 debts, even though you don't, because the Capital One debt has been extinguished by the sale. Also, stale entries. Entries that are older than 10 years are not supposed to be on a credit report. Re-aged debts. So re-aged debts mean that once a debt is sold, if it's still past the 10 years, it's not supposed to be on the credit report. But because it's been sold, they re-put it on the credit report, even though it's too old to be there. Other errors are unidentifiable accounts. So if you had, let's say you had a American Express card and they sold it to Financial Center LLP, and all you see on your credit report is Financial Center LLP. You don't know what that is. So that's a debt that someone can't identify. Joint accounts where you don't have any actual liability will appear on your credit report. Merged files. So if your name is common or the client's name is common and the file gets merged with someone else, you will see that on the credit report. Mortgage modifications. Now this is large because most mortgages are much bigger than what's owed on credit cards, excuse me. So what you'll see is, let's say your first mortgage was with, and you might see 3 or 4 of these. So let's say your first mortgage was with NationStar. So NationStar will have a trade line saying you owe $300,000. And then let's say Ocwen became the servicer. So Ocwen will have a trade line saying that you owe $300,000, even though you don't, because Ocwen isn't your mortgagor. And then let's say NationStar sold your debt to Bank of America and you modified with Bank of America, then you'll have another trade line for Bank of America. So it will look like you owe $900,000 when in actuality you only owe $300,000. So also settled accounts will appear as not having been settled, and that's something, a settled account is obviously better than an open delinquent account. So disputing and rebuilding credit. So there's a couple of things that you can do to dispute data on your credit report. MyFairCredit.com runs through several letters and samples and ways to dispute the data in writing. You should always dispute it in writing, always certified mail return receipt requested, always keep a copy, send the letter from the debtor, because there is a cause of action here, so it needs to be sent from the debtor. It goes to all 3 of the big CRAs, credit reporting agencies, and it should include anything you have with regard to the disputed item, the account number information, and briefly describe the reason for disagreement. I don't believe this is my debt. I don't know who this company is, something like that. So And credit reporting agencies have 30 days to respond. So now what that means is that if they don't respond within the 30 days, they can take the debt. They're supposed to take the debt off the credit report. But if it gets re-reported, it gets put back on. So it's actually better if they do the investigation than to just remove the debt, because if it is a recent debt and it's going to get put back on, that will be a problem because your clients will see it there again. And this is what the unscrupulous credit agencies that claim they can fix your credit do, is they send tons of these letters, they get it taken off your credit report, and it looks great, and then you pay them, and 30 days later it all pops back on. So it is better to actually resolve these. So when you're disputing data with the creditors, you want to use the exact same format, but because there's no private cause of action, you don't have to send it to the original creditor. So you can send it to whomever is on the credit report. So some ways to rebuild your credit report safely. I will say this, and this is unfortunate. It could take 2 months to destroy your credit, and it can take 4 years to rebuild it. So this is a very slow, methodical process that your clients have to go through. The first thing they can do, and they have to look at the safety precautions here, because anything they do is going to be put on their credit report, any address, any new entity, any bank they're using. So they do need to be careful. So the first thing they can do is get a secured credit card from a bank. Secured credit cards do bring up your credit score because you're using them only up to the limit you have. You can ask the landlord to report current rent payments. Some of the larger landlords will do this. Some of the smaller landlords, unfortunately, will not. Store charge cards. So charge cards that are only good at the store that's printed on them are easier to get. Always have your client keep their balances low, so they should use the card every month and pay it off every month. That helps rebuild your credit more than not using it at all or using it a lot and then carrying a debt. Keep the amount they use low. So if they're using a credit card on a monthly basis and it's a $500 limit, they shouldn't be using $450 every month. They should use $200 every month and pay it off. So, and also remind them that having no credit is worse than having bad credit. So it is harder to establish when someone has no credit than it is if they want to bring their credit score up. So we talked about some of this. Remember that anyone can illegally pull a credit report, unfortunately, as long as they have the right information. When applying for a credit card, you can always use a P.O. box. I have not found one credit card that has denied a P.O. box as an address. I never give phone numbers, or clients never give phone numbers to the creditors or the agencies. And do remember that whatever they're applying for can be tracked. So they need to be, especially if they're applying for something from a small bank, they need to be careful. So, okay. So I want to talk a little bit about some new developments and a settlement that came out of the New York Attorney General's office. So it's the National Consumer Assistance Plan. It was a settlement launched by the Big Three after the New York Attorney General did a large investigation. And it was meant to accurately address credit report data and medical debt. Medical debt is a big problem with a lot of credit scores. It unfolds in 3 phases that start March 9th of 2015, and they go over 3 years and 90 days. So the Big Three, as I said, they go through these automated systems. They use binary code. There's a lot of mismatches. That was one of the problems. The other problem with medical debt is that medical debt was reported very quickly once it was owed, and it was reported and went into collections even before the insurance company had the ability to pay. And so you need to, so clients were getting medical debts that were reducing their score tremendously, and collections calls for medical debts when they actually didn't owe it. It was just that their medical provider, their insurance company, hadn't paid the debt yet. So the settlement terms are this: the creditors cannot report debts that don't arise from a contract to pay. So that's fines and tickets, certain fines and tickets. They have 180 days before they can put a medical debt on the credit report, and they must remove, this is big, the credit agencies, the CRAs, are required to remove the medical debts that have been paid or are being paid by insurance. So they're supposed to go back into credit reports and remove these debts. I can tell you that they are probably not going to do this, and the best thing that we can do, because this settlement will be monitored, is for our clients to look at their credit reports, and if they have medical debt that is either less than 180 days or has been paid already, that they notify the CRA, and if the CRA does not remove it, that you notify the Attorney General in your state, because this settlement will be monitored. So consumers can now get a second free credit report after disputing an error. They used to not be able to do that. And their CRAs are supposed to create a consumer complaint department that including specialized groups. That is the most ambiguous part of the settlement, so I'm not exactly sure how that's going to play out, but it is something that we'll see. My guess is that'll probably be towards the end of the 3 years. As we see the benefits, that's what we talked about. The problem areas, of course, are still that survivors have to provide current location and current contact information to dispute results. So it's a work in progress, and we'll probably see in about 2 years how effective the whole settlement has been. If you're not in New York, and I know most of you aren't, you should contact the local Attorney General and see if they've signed on to it. They do have a time frame to sign on to it. If they have, then all these settlement rules will apply to your clients. Regardless of whether they have or not, I would still check your client's credit reports, especially looking for medical debt. And also, if your Attorney General has signed on, your clients need to remember that the medical debts, if they're going to be paid by a medical insurance company, that they shouldn't be paying those themselves. If they want to start cleaning up their credit, they should not look at the medical debts. They should be looking at the other debts. And of course, something to think about when you are talking about paying off debts is that which debts should be paid off first and why. You know, first, is your client income collections proof, as we call it, meaning that does your client have income that is so exempt that they're not going to be, there's going to be no judgment against them that's going to be able to be collected. And if that's the case, then settling these debts sometimes can be easier. Also, discuss with your clients why settling smaller amounts first will help their credit score. For example, settling older accounts, because you can settle older accounts for much less money, and then they have more money to pay other bills. That will help. And, of course, talk to them about aggressive creditors. There is the Do Not Call, which is online, the Do Not Call website, and where they are not supposed to call if they are listed on the Do Not Call list. Okay. And we're going to, so there's a New York Times article. There's a full settlement agreement if you want to read it. It was really delightful reading. It put me right to sleep. And there is the CSAJ fact sheet, which is coming soon, which will have more succinct terms about this settlement. And I just want to mention, because I've been looking at the questions, so there are agencies that, such as Credit Karma, and that will give you a score, a credit score. It's not the most accurate credit score. And some of these, like Credit Karma, is run by TransUnion, so they can be helpful, especially when your client is constantly wanting to check their reports and check their scores and see what's going on. They set up alerts, but you have to remember that even though they are useful, and it's one of 3 agencies. So Credit Karma, I believe, is TransUnion. And so all you're seeing is TransUnion, which means if your client comes back and says, Credit Karma says I have a 780, but my credit score on, when I applied for a credit card was 650, that's because TransUnion thinks you have a 780, but the other 2 may not. So and I believe all 3 are creating their own kind of Credit Karma, and they're all free to enroll and join. You do need an email. But they can be useful for what they are, and what they are is a tool to assist your client in understanding and knowing what their credit is looking like at that moment. So, okay. So I want to move on, and we'll save some questions for the end. And I have been looking at some of the chat, so if I missed something, I apologize. So strategies to address credit-related challenges. So, and some of these we have spoken about. Choosing a P.O. box or a billing address, security freezes. Some states have laws that require credit reporting agencies to place freezes free for domestic violence survivors. Just remember the freezes expire. Some are 30 days, some are 90 days, but they expire. So your client has to be very aware of when they're going to expire to ask that it be continued. You can also have fraud alerts. So a security freeze is where no credit is going to be given out at all. A fraud alert is when, if somebody contacts to seek credit, your client gets notified via however they ask to be notified. So if your client is really nervous that someone is taking out credit in their name or they're a victim of identity theft, I would do a security freeze. But they need to recognize that they're not going to be able to open any new credit cards or apply for any credit during that time. So CRAs also, as I said, do merge old and new identities. And so if they are changing their identities, they need to be careful because it may wind up that the 2 identities merge on their credit report. If a security freeze is about to expire, like it's the 88th day or the 89th day of the 90 days, they should call the CRA and request that it be extended. And they can request that it be extended either if their state is, because they're a victim of domestic violence and their state agrees to that, or if the identity theft issue hasn't been fully resolved, or if there's been new identity theft issues. So what they do is they call in advance and they say, I need the security freeze listed. So the security freeze and the fraud alert are really the only 2 things the CRA has just to prevent getting new data. The problem with both of these are accessing the file if the client has, if the client's information is out there and the other party has it, then the CRA has almost nothing available to stop accessing the file. You can request that the only access of a file be through mail or through another way, but many CRAs don't have the capacity to do that. So once the other side has all their information, it is very difficult to stop them from accessing the file, unfortunately. So I want to talk a little bit about various debts. And a lot of our clients come into our office about, saying we're married, so all the debts, I owe everything that they spent. That's not 100% accurate. Debts accumulated during a marriage are considered marital debt, and both parties may be liable of the debt regardless of whose name is on the debt, only in a divorce. So in a consumer action, if if the husband is the only person on the debt, the consumer action, they cannot go after the wife unless it's medical care or necessaries, which is food or clothing, and they don't normally do that for regular credit cards. So if your client comes in and says all the debt, magically comes in and says all the debts are in my husband's name, you can tell her that in the consumer action, she's not going to get sued. In the divorce, there is a strong probability that the debts are going to be considered marital, and there are exceptions for that based on what state you're practicing in. But there's a big difference between what you're liable for in a divorce and what you're liable for in a consumer action. If you are not married to someone, and this is also true for consumer actions, the account holder is the one that's liable for the debt. If you are an authorized user on the card, you are not liable for the entire debt. You may be liable for the charges you specifically charged, and they usually don't even distinguish them that way. But the creditor the creditor only has the right to sue the person who is the account holder, not the authorized user in a debt. Now, that being said, creditors are notorious for suing authorized users and telling them in court that they are required to pay this debt. That is not correct. If they are not a joint debtor or the contract holder, the debt holder, they are not going to be liable in court. So if you're a joint debtor, you're considered a co-borrower. As a co-borrower, you are liable for 100% of whatever was spent on the card. It's the same as a mortgage. If you're a co-borrower on a mortgage, you're liable for the entire mortgage. So when someone comes to you and says, we jointly have this card, and you need to talk to them about what that really means, whose name the debt is in. But if they say we jointly have this card, what they're saying is that we're both liable for 100% of that debt. And they're going to go after whoever they can first. So whoever they find first is what the creditors are going to go after. So separating credit from a former partner, the first thing to talk about is safety, because a lot of this is going to involve the former partner finding out what they're doing. So you really need to talk to them and go through it safely. So if the former partner, if there's joint credit cards and you cancel them, they're going to know about it. So I don't recommend some of these solutions if the parties are still living together, if they're still afraid of them, and there's a reason or a cause that they think they're going to do something. I would say you need to hold off on some of these things. But you should always cancel all joint credit cards, cancel all authorized user accounts. If you're no matter whether you're the authorized user or you're the account holder, you need to cancel those cards. Cancel credit cards that are known to the abuser. You could just call and say my credit cards were lost, and they'll reissue you new credit cards. You got to look at all your different contracts. Once they are completely free of the situation, they need to review all the beneficiaries with them. There are several recent cases. One made it all the way up to the Supreme Court, where the insurance policy went to the first the ex-wife instead of the current wife because they forgot to change the beneficiary. So that's something to always go through. And a lot of our clients who are employed may have, an IRA or 401k, and so they want to make sure that they change the beneficiaries. I would also suggest that they change banks and even credit card companies. So if they've always banked at Citibank, I would say go find another bank. This way that the abuser can't even just attempt to go into Citibank. And of course, change all passwords. As soon as they flee, they should be changing all the passwords. So we're going to look at this scenario very briefly. So Rebecca and her husband are in the process of obtaining a divorce. Rebecca knows that her husband has opened accounts in her name but is unsure of what. As part of the divorce settlement, Richard has agreed to assume responsibility for the debts. Lately, Rebecca has seen a lot of collection calls. Which debts is she responsible for? So This is a page of a credit report. The three things that you see on here are called trade lines: Ocwen, Chase, and Dell. So the question is going to be, which one is she liable for? Now, if you look in the polling section, you'll see A is none of them, B is all of them, and C is Ocwen and Dell. So what we're gonna open the poll, and if you could just click on what you think the answer is, and then we'll go through it. All answers are anonymous, so we won't know. How are we doing with answering?
We're doing all right. I'm going to wait for one more minute to see if we can get some other folks to give it their best guess. All right, I'm going to close up the poll so we get a good guesstimate.
Okay. Okay, so while we're waiting for the response, basically what you needed to be looking at for all three of them is on the right-hand side. It says pay status, account type, and responsibility. And it seems that Ocwen and Dell are the winners, which is number C, and that's also the right answer. And the reason for that is because on that side where it says account type and responsibility, Ocwen is a mortgage, and it's a joint account, so therefore both parties are liable. Chase is a revolving account, and it's authorized. That means she's an authorized user. Dell is an individual account, which means it's her account specifically and no one else's. So congratulations to those who answered C. You got it right. So Rebecca has never heard of Dell. What do we think the first thing is Rebecca should do? We're running close to time, so obviously, just to let you know, the first thing she should do is take that trade line and contact Dell safely and find out what the account is, ask for the paperwork on the account, and see exactly what is. The other thing she should do is, if she is separated, because this is during the divorce, she should close that account immediately. And then that, of course, will trigger her having to start paying it, and then she can incorporate the payment of the Dell account into the divorce, because they are married and getting a divorce. A lot of debts should be dealt with in the divorce. Clients who get divorces not dealing with the debts, unfortunately, put themselves in a very, very difficult position. So we're going to talk a little bit about system advocacy to address credit-related needs of survivors. So there have been some systems advocacy related to credit. We talked about the New York Attorney General settlement agreement with the credit the CRAs. There's also been protections for survivors by the CFPB, which is the Consumer Financial Protection Bureau. They have a complaint database. New York City has created a ban on employer credit checks. And there's collaborative work that's going on with CSAJ. So
let me just pipe in for 1 second. So these last two bullet points on the New York City ban on employer credit checks, I had mentioned earlier that we're going to be having a webinar in October that will be focusing on credit checks, and we'll definitely be talking about New York City's new ban. And then the second piece of this is really more about some of the pilot site work that CSAJ has been doing in different locations throughout the country, where we've been working closely with some communities, some states, around trying to collaborate to meet some of these needs on a more systemic level. So if folks are interested in bringing some of that to their own communities, you can feel free to contact us about that, and we can see what we can do.
Okay. So the CFBP is trying to be helpful now that it's fully together and working in assisting survivors with issues regarding financial products. So and they have offices in many cities outside of Washington, D.C. So I highly recommend working with them or speaking with them. They are open to coming in and talking to people, to discussing things. They do have an advocacy wing where they go and teach people different things. So I recommend connecting with them if possible. So, okay. So does anyone have any systems advocacy that they have done or have thought about doing? They're welcome to put it into either the Q&A or the chat box. And while that's going on, I just want to answer one of the questions about debts in the wife's name, and the husband is ordered to pay the debts in the divorce. Is there any way to get the creditors to stop collecting from the wife? Unfortunately, no. What you can do is if the creditors file an action, I have brought in the husband into the credit action, and I have gotten agreements from the husband to pay. I've also filed actions in the divorce, post-judgment enforcement actions in the divorce. But the creditor, if the debt is in the wife's name, the creditor does have the right to collect from the wife, and actually they don't even have the right to collect from the husband because they're not party to the divorce, so they only have the right to collect from the wife. So, does anyone have any systems advocacy?
And we'll be talking more about that in October, so I think we would love to hear about things going on around the country because it definitely informs the work that we do. So hopefully we can chat more about that during our next webinar.
Yeah, okay. Okay, I tried to cover all the questions. If anyone has any other questions, feel free to type. In the meantime, I'm going to turn it over to Erica to talk a little bit about CSAJ and Part 2.
Thank you, Laura. I just want to thank you so much for that, all of the incredible information and strategies that you have just offered to all of us. I think that everybody can understand why Laura is such a critical aspect to CSAJ's work. So thank you so much for all of your insights today. I want to thank everybody for joining us today as well, because all of your questions really were very thoughtful and contributed to a lot of the conversation. So thank you for that. In terms of CSAJ, I am certain that there are questions that have come up during the course of today's webinar that you may be interested in getting some more information about. You may have individual casework that comes up where you're interested in getting some more concrete expertise or advice as you're working with clients. So CSAJ is available to help folks in thinking through those concrete case issues as well as thinking with your organizations and your communities about how to address some of these recurring credit-related and other economic justice-related issues facing survivors. So our contact information is listed right here. There's our email and our website. And there's all sorts of resources available on our website about many of the things that we've talked about today. I also know that following today's program, you'll be getting an email that contains the PowerPoint and the tool that we're developing around some of the settlement language and some concrete strategies for that, and perhaps some other gems too that might be useful to you. So keep your eyes open for that. And I think that is all. Sarah Wee, thank you so much for coordinating today's program. Do you have other pieces that you want to add before we close?
Nope, that's it. Just check your email. You do not have to be listening in live to receive an email from us with the recording, PowerPoint, and other gems, as Erica mentioned, that we should be able to get that to you by Monday at the latest. So just keep your eyes out or make sure you check in with our website for those materials to be posted.
Wonderful. And thanks so much, everybody, for joining us today. I hope you have a great afternoon.
Thank you, everyone.